15 minutes per side of your argument. Would you like to reserve some time?
No. I would, Your Honor. 5 minutes, please.
So noted, counsel. You may proceed.
May it please the court. Good morning. My name is Matt Baggett for the appellant, Gerhardt. We are here on a pointed legal issue, and that issue is that late last year in this courthouse, we had a ruling from a trial court judge on a motion to dismiss a third-party complaint for contribution and indemnity, but we're only here on contribution. And that ruling dismissed our contribution claim with prejudice, and that ruling removed the right of a defendant in Florida to third-party in another non-party to the case. The plaintiff didn't sue in the negligence action.
Other than the second district, is there any other court allowed?
Nothing.
They had a ruling that was in court with the trial judge.
Nothing, Your Honor. We found nothing, and nothing since.
Then what would happen if we affirmed you would go back and this case would be tried with the third-party defendant as a fabre defendant, but they wouldn't be a party, they would just be listed on the verdict form?
Correct, it would. We've already made it an affirmative defense. They are listed, they are there. Both appellees, the individual tax advisor and his company. Not having them in the case is significant because whether it's this case, whether it's any defendant's case going forward, because we can't have them at the mediation table. They won't be here as a real party at counsel table at trial. They won't be a part of the litigation. In holding that, as the second district did in the TNS Enterprises case, non-party portion is enough. Well, we don't think it's enough at all. And not only do you have the practical considerations of they're not there for mediation.
The jury is free to allocate fault to the non-party as well. Is that correct?
Correct, Your Honor. We believe, our argument is that there is a more practical benefit to having them in the case. And the TNS Enterprises case, the TNS Enterprises ruling ignores the practical considerations that I mentioned. It ignores the modern use of contribution. Today, contribution is used as a tool to bring a non-party in. The plaintiff didn't sue. Whether they did, for whatever the reason may be, they're
Let's talk about the substance of this lawsuit. I believe there are 4 counts. One
Correct.
of which is fraud. You don't think you can lay off anything you get tagged for fraud on a third party, do you?
No, we
Breach of fiduciary duty, same analysis.
correct.
So 2 other counts. One is failure to procure an insurance policy.
Correct.
That can be laid off on the insured's tax advisor.
No.
All right, so that relieves misrepresentations about who's going to own the policy and the ease with which and the power to get advances.
Correct, Your Honor.
So on that theory, also, how does the insured's tax advisor become liable?
They become liable because this is a negligence case in general against multiple parties. And we believe it's not the precise nature of the allegations against us, but it's the fact that it's a negligence case. 2 of the 4 counts, as you pointed out, are based in negligence, and the comparative fault statute brings them under the umbrella of a negligence case, and that, therefore, gives us the right to make that contribution claim, to bring them into the case, to answer for their own apportionment, to allow the jury to answer for their own fault, and to allow the jury to apportion to them. So it's not so much.
Which 2 counts are you referring to, counsel? Count 1, 2?
I believe it is 1 and 2 are the negligence-based counts.
All right, now you agree if we followed TNS, you would lose.
Correct. We have exactly the same posture as the TNS Enterprises case. TNS,
What is your quarrel with the TNS court's interpretation of the statute?
the second DCA, in a fairly brief opinion, really wiped out a long-standing 30-year right. They did it without considering those practical considerations that I mentioned. They did it without considering the modern use of contribution. There's a jury instruction directly on point, a Supreme Court jury instruction for the when a claim for contribution exists as a third-party complaint against a non-party that was brought into the litigation. What that jury instruction asks, it charges the jury with apportioning the negligence among everybody, among all of the primary defendants in the case, including the third-party plaintiff and the defendant. So it allows the jury to look at everybody, apportion fault based on their percentage of liability, and then the court can enter judgment based upon that.
Well, a third party shouldn't also be a defendant on the main claim.
It can be. It can be.
So that brings us to the other second district case, the one that followed TNS, Claudio.
Well, Claudio actually declined to find that TNS was relevant to their case. The Claudio versus Regalado case is a case where the court found a need for contribution as a counterclaim. It happened subsequent to TNS Enterprises, right after the second district court, not right after, a couple of years after, but right after the court found the contribution no longer exists. Well, in Claudio, they then say, well, wait a minute, we need contribution in this situation for a counterclaim. It was actually a mother and father. The mother was in a car accident. The mother was found to be partially responsible, and the defendant had no remedy because she was not a grave party. She was an actual part of the litigation. It was multi-plaintiff litigation. They found that they did need contribution in order to apportion fault to her because she can't be a grave. That's more of a unique situation, but fundamentally, do we have contribution or do we not? Does contribution sync with the abolition of joint and several liability, or does it not? We don't believe it does. One important...
Let me ask you a quick question. If you went to trial and a jury verdict comes out and your client's held responsible, and let's say that this third-party defendant wasn't listed, wouldn't it be a classic contribution claim then where you actually have a judgment against you for which you want to see contribution against someone else?
We don't believe we would have a post-judgment contribution claim. If the jury apportioned between, and we will have them as a federal defendant, we will have them, and we will request non-party apportionment. We will plead and prove that case against them. That's fine. And that's the basis of the TNS Enterprises case. Well, that's good.
That would move any third-party claim, though, wouldn't it? See, if the jury apportioned fault between you and the federal defendant, that would move any third-party claim against this federal defendant, wouldn't it?
We would have to live with that. Post-trial, post-verdict, we would have to live with that. We cannot then make a contribution claim because the law says, well, they apportioned appropriately and they were already listed, so you have to live with that. The problem is that does not...
Aren't you in a stronger position in trial if you don't have anybody arguing back?
Our case is this, and this is a record. These folks are pals. Mr. Crowe, the plaintiff in this case, this is a longtime friend and tax advisor of his. He was there, arm in arm, throughout his decision to invest in this product.
So if he's going to be a power defendant, you're going to have discovery as to his relationship and what he said, and he's still going to be deposed, there's still going to be discovery as to him, correct?
Correct.
And what I'm struggling with is, assuming we affirm moving forward on this, what's the verdict form going to be looking like? Typically, if it's just pure negligence, you're going to have an apportionment between the different parties. But here, the theories against Gerhardt are fraud, breach of fiduciary duty. How is this going to appear in the jury instructions in the verdict form? Because they're not apportionment claims. Well, let's assume for a moment they're not. But how are you going to set up a jury verdict form?
The verdict form, well, I think the court would likely, because all 5 of the defendants, are the same 4 counts against all 5 defendants. And so what the court will likely do is they will simply add the 5 or 8 defendant to one or both of the negligence counts and have them apportioned that way, or perhaps the court will be more creative and combine them. But regardless, we certainly have a right to name them and prove and allow the jury to consider everything. And certainly the tax advisor, we argue, and we will argue at trial, this is the guy. It's not my client, the seller.
Yes, Counsel, but as a follow-up to Judge Benson's question, from a defense perspective, and as well as from a tactical point, aren't you in a better position having a fabric defendant there where you can point things at him as opposed to him being there physically to defend himself?
Not always. Not always. And that's trial. And strategic considerations may agree with Judge Benton in that case. We want a mediation first and foremost. We want a mediation. The state favors mediation. We think we have the right to bring him to the table. We think we've had that right for 30 years, and that more consideration needs to go into the removal of that right. And it's important. That's why we're here. That's why we made this appeal. Because not a party apportionment is not always good enough. So I'll reserve the balance of my argument.
Thank you, Counsel.
Thank you, Your Honor. So may it please the court. I am Richard Steedman. I represent the appellees, Sam Gerhardt and Gerhardt, this company. As I listened to opposing counsel, it struck me that one of the first things that he said is that the current posture of the pleadings is that his client has amended and has asserted a fabric defense. And Your Honors took up some time toward the end of the discussion to talk about isn't he actually better off with a fabric defense? And there was a lot of discussion about the right to bring in a contribution claim. What I did not hear, at least, was anything about the statutes, the interaction of the statutes, and the fact that since he has asserted a fabric defense, there is no possible way that his client can be held responsible for more than his client's proportionate share of responsibility. Under the contribution statute, a threshold prerequisite for the application is that you must be responsible for more than your pro rata share of the responsibility. There are 2 exceptions to that case. We saw one in the 2 second DCA cases, one having to do with the counterclaim, which had to be filed to preserve the position, and the other having to do with post-judgment claim for contribution, which in TNS said would still be available.
Well, counsel's position is he wants your client present at mediation. Is he better off having your client present at mediation?
I think Your Honor has identified precisely what is really going on here. I think these arguments about the right to have someone at trial is completely disingenuous because, as your comments indicate, the old adage about the empty chair, most lawyers would much rather have an empty chair than a chair that's full and fighting back. What they would like to have, conversely, is a full chair at mediation so that they could squeeze them for settlement. That's what's really going on here. But I think, given the 2006 amendment to the comparative negligence statute and its interaction with the contribution statute, that option is not available to them as a matter of law and as correctly decided in the TNS case. But Your Honor has identified the second elephant in the room. We heard about one in the first argument. But that's what's going on here. And really, when you look at the contribution statute, and you have to look at the history of contribution, which is an equitable remedy. And the reason that we have contribution, is so that a person would not be responsible for paying more than their share. Given the revision to the comparative negligence statute, there is no purpose under the circumstances of this case for that remedy to exist. And in fact, when you look at the comparative negligence statute, it says that the jury must make a determination based on fault, objectively, not based on equitable grounds. And what's interesting is when you look at the contribution statute later, it talks about the court may consider certain equitable principles in allocating fault, which of course is diametrically opposed to the comparative fault statute. So the guiding scheme, and I think in the two Supreme Court cases, the Wells case and the Gowdy case, which...
what do you say to this point that the jury instructions still allow bringing in third parties?
Well, if I may, Your Honor, read from the decision that the appellant relied upon in their brief, the Supreme Court says, in authorizing the publication and use of the standard civil jury instructions, we express no opinion on their correctness and remind all interested parties that this authorization forecloses neither requesting additional or alternative instructions nor contesting the legal correctness of the instructions. We further caution all interested parties that any comments associated with the instructions reflect only the opinion of the committee and are not necessarily indicative of the views of this court as to their correctness or applicability.
Well, that's standard language. I mean, they always put that in because the jury instructions don't become law. They're just advisory and like guidance.
Correct.
I'm TNS. It's an unusual decision. As I read it, it doesn't even come out and say that the statute overturns prior decisions that allow what folks want to do. It said that the enactment of the statute appears to have rendered these prior decisions obsolete. This is, while the cases cited in this opinion may not have been overruled, they are rendered obsolete, at least in cases like this one. I read that as a pretty weak precedent, meaning it's not Bushwick's gore, but it's saying this in this case is just obsolete. I don't read it as a precedent saying across the board, never, never, never.
I would agree, Your Honor. Far from me, I've never sat there, so it's difficult for me to question the opinion writing skills of the second DCA. But I would call that a thin opinion. I don't think the opinion was well developed or well.
But you would agree that if the appellant is to prevail in this case, we would have to declare a conflict with TSS.
I believe, Your Honor, you're absolutely correct. And I think that, again, if you go back to Gowdy and its predecessor, which is Wells, and Gowdy adopts Justice Ansted's concurrent opinion in Wells, which although they were dealing with offsets, they were dealing with the interaction between the comparative negligence statute and the contribution statute. And in that opinion, that is in Gowdy, which again adopted Wells, they said, and I think that this is an immutable principle, if there is no longer any chance of a party being held responsible for more than their pro rata share of liability, then there is no right to contribution. And if you look back at the contribution statute, in the very first sentence, or second sentence, it says the right to contribution shall only pertain where a person is responsible, actually it says she or he, is responsible for more than his pro rata share of liability. I mean, it's implicit in the statute that contemplates not only post-judgment, but potential judgments. But the history of the decisions of Gowdy and Wells and their discussion of how these two statutes interact, in fact, in Gowdy, the court said, we believe that the legislature, having left these schemes intact despite these revisions, we believe that they want the courts to sort out what the intent of this is. Those are the words of the Supreme Court in Gowdy.
Isn't it also the case that the abolition of joint and several liability does not apply in certain cases, like the Chapter 403 pollution case?
That's correct, Your Honor. But that's specifically provided for in the contribution statute. But that situation is distinctly different.
That would explain the fact that the Supreme Court's jury instruction remains in the books.
That, again, I think that the disclaimer is such that the Supreme Court understands that jury instructions are fluid and that ultimately it's up to the trial judge to decide what jury instruction is or is not appropriate under the circumstances. But there are other potential circumstances, such as a party may have a claim for equitable subrogation, which that instruction may apply to. So there are potential circumstances where it might apply.
Well, do we have to wade into this swamp? I think that we got a concession on counts 3 and 4, the fraud and breach of fiduciary duty counts, that contribution is not available. But he said on counts 1 and 2, those are negligence counts, and therefore any professional negligence the tax advisor was guilty of should be in the mix.
Well, I think, Your Honor, you're absolutely correct. And to some extent, the third argument ties into the second argument. But clearly, the contribution statute excludes breach of fiduciary duty. It excludes fraud, which are 2 of the counts. The other count is they did not get us the insurance policy that they promised they would get us. Obviously, the accountant could have had nothing to do with that. And the thin allegation as to the accountant is the legal conclusion failed to render or negligently render tax advice, which has nothing to do with obtaining policy. And that leaves us with the last count, which is count 1, which has 2 allegations relating back to the original complaint, having to do with not discovering that the IRS had not approved this tax scheme, and 2, not discovering that the plaintiff would not be the owner of the insurance policy.
Not disclosing, you mean?
Not disclosing. And once again, I think the case law is clear. I think it's an McGrath case, but you must look at the allegations in the underlying plaintiff's case to see if there's some basis to sustain the claim for contribution. In this case, I don't think there is. They cite the Gulfstream case out of the 4th TCA. There's a subsequent case out of the 4th TCA, which I think is actually more on point. But even though the ultimate injury may, in some circumstances, be the same thing, some interest and penalties, the infliction of that injury is different. And basically, what the third-party contribution plaintiff is saying is, we constructed, we solicited, and we sold a product that was defective at the time that we passed it along to you. We also represented that some governmental authority had already said that this thing was intact and whole. They now want to bring us in as a defendant to somehow lessen their liability for something that is already a complete tort. And the essence of it is, you should have discovered our error, and you should have stopped us from doing what we did. That just doesn't make any sense. And ultimately, I think the reason it doesn't make any sense is because ultimately these are not joint tortfeasors. There's some discussion.
Well, your client should probably be considered in the fraud claim, for example. In other words, if the purchaser did not rely on their representations, but relied instead on his advisor's opinion, then that defeats one of the elements of fraud.
Well, I don't think he would be a party. It may be a defense to them, but I don't think it would be a basis for sustaining a claim of contribution as per the statute. But ultimately, I don't believe that under the circumstances, whether or not there is a statutory remedy, which I think TNS correctly decided there is not under these limited circumstances, I also think that there's not a claim for contribution under the peculiar facts of this case, given the underlying pleadings of the plaintiff's case and the causes of action asserted. And that somewhat dovetails into the third argument, which is, I'm an accountant. What they're really talking about is professional malpractice, which has to do with the rendering of advice negligently under the circumstances. And once again, as pointed out, we as lawyers give advice all day long. The fact that we may ultimately be proven wrong is not tantamount to malpractice. There's no allegation whatsoever in this complaint tying these things together or somehow showing how what we allegedly did would be the proximate cause of what
Your client's advice was to, in one view, their mark and was not for their benefit or intended in any way to be something they get around.
That is correct. That is correct. And again, given the thin allegation in the complaint about negligently rendering tax advice, we really don't know what they're talking about.
Well, why shouldn't it be without prejudice? This is with prejudice.
Well, I agree, Your Honor, that if the...
So they seek leave to amend the law.
Well, I think if the court believes that, as a matter of law, the remedy of contribution does not pertain as decided in TNS, and I'm not relying on TNS, I think it's correctly decided, but I think the statutory interpretation of 76831 and 81, in conjunction with Wells and Gowdy, supports that decision, irrespective of their thin written decision. But if the court does not agree with me on that point, then as to the second point, whether or not there is a claim for contribution under the facts as stated or as alleged, I agree. They should be given leave to amend. So,
Did they ask for leave of the law?
Subsequent to the order of the court dismissing the complaint of prejudice?
Did they ever seek to amend?
Not that I'm aware of.
So why should they be able to come up on appeal and ask for that?
I will say this, Your Honor, and I probably should not grant them quarter on this, but I will say that the judge's order dismissing the complaint with prejudice does not express the rationale of the grounds, and it may have been something akin to a lesser included offense, and he ruled on the dispositive portion of the motion to dismiss, and perhaps it would be appropriate, if the court does not agree with the dispositive grounds, to grant leave. That is this court. Thank you.
Thank you, Counsel.
We will rely on our brief or any argument other than the contribution argument. This dismissal with prejudice by Judge Haddock on the first motion to dismiss was because he agreed with TNS Enterprises. I don't think that's the only probable conclusion here. So we are talking about...
And if you prevail in this appeal, Counsel, this panel would have to declare conflict with the Second District's opinion in TNS Enterprises. Is that correct?
We believe that, yes, that is absolutely correct.
Well, you give us your best shot as to why TNS Enterprises was erroneously decided. In other words, give us a roadmap as to how we get there.
The roadmap is the way we see it threefold. You have, and there is nothing disingenuous about what we're saying. Everything I'm saying is in our briefs. Absolutely, this state favors mediation. We want them not holding feet to the fire, not squeezing based on a meritless claim or anything like that. We want a real threat of liability at trial. That's why they're going to help us resolve the case.
That's a policy argument. I'd like to hear some legal argument.
Let's talk about the legal argument. The statute itself. The statute itself speaks in terms of a contribution right for joint or several liability. That is argument one in our brief. There is an or in there. That is an or, it cannot be ignored. So, and what several liability is apportionment. So you already have, based on the statutory language itself, an ability to use contribution in several liability cases. There's no disputing the contribution statute was created to address inequities with joint several liability.
Well, wouldn't your best argument that if the legislature had intended to overturn 30 years of practice, it would have said something about that?
Yes, that is a very strong argument, and that's part of this whole appeal. Well, we have a contribution statute. We have a contribution statute we have to live with. Is it just supposed to be used.
I mean, TNS that was frank and said, look, we're essentially overturning 30 years of practice because we think the statute renders that practice, quote, obsolete.
Correct. And what they're seizing on is the contribution is only there when you pay more than your pro rata share. But that's not
for those purposes, and also there are certain classes of cases.
correct. Certain class of cases, other than what I'll call traditional negligence cases, which is what we have here. But in doing that, they are not paying credence to how contribution is used today. Yes, it used to be something there as a cause of action when you pay more than your pro rata share because of the existence of joint several liability. All of that changed 30 years ago when the law uniformly began to say, well, you can use contribution as a third-party action. You can use contribution during the pendency of the case, and then when you get down the road, everybody's on the verge of going together.
But is your position that the current version of Section 768, 181 had no effect on all the prior precedent cases out there? The 30 years of practice of cases that you referred to?
No. Yeah, correct. We don't believe it did. We believe that that's why it was continued to be practiced that way. That's why it's practiced in every district today, except for the second district, because of that. So we would ask that you not follow the second district court of appeal, and that you allow the use of modern contribution as it's used today as a tool to bring culpable parties not sued by the plaintiff into a case for real liability and to atone for any culpability in a negligence action.
Thank you, Counsel.